Hello, I'm Thomas Fuller from Omny Law, and in this module we're looking at handling disciplinary issues fairly. Disciplinary situations are one of the most common and highest risk areas for line managers. Getting them right isn't about being harsh or soft, it's about being fair, consistent, and following the right steps. As a line manager, disciplinary issues often land with you first. It might be due to repeated lateness, conduct problems, or concerns raised by colleagues. One of the biggest risks I see is managers acting too quickly, relying on their instincts when responding to issues that are brought to their attention and justifying their behaviour after the fact, rather than pausing and following a fair process. From a legal perspective, disciplinary action must be fair, and for it to be fair, there are typically 3 stages involved. The first is an investigation into the concerns. The second is that, if there is a disciplinary case to answer, the employee is given the opportunity to respond to those concerns. Finally, where a decision is made, the employee is offered the right of appeal of any disciplinary decision. It's not about punishment, it's about making a reasonable decision based on facts that are supported by evidence following a reasonable level of investigation. When it comes to handling disciplinary matters, the disciplinary officer should take the following steps. Firstly, pause. When a matter is brought to your attention, do not react in the moment. This is important because any knee-jerk decision, possibly based on frustration or hearsay, made at this early stage of a disciplinary process could impact the fairness of the process later on. Instead, note the concern that has been raised and move on to step 2, which is to prepare. Preparing for an investigation typically involves gathering evidence, which may be evidence such as emails, letters, other relevant records, CCTV, or even speaking with witnesses. It may also be helpful to gather dates and times of when events are alleged to have happened, and whilst it is not always necessary to hold a separate investigation meeting with the individual in question, if your company policy requires this as a separate stage, then you should meet with the employee to obtain their version of events. By this point, you should have all the relevant evidence established from the investigation, and if it is believed there is a case to answer, then the employee can be invited to a disciplinary hearing. They should be given the right to be accompanied by a trade union representative or a fellow employee, and forewarned in the invite letter the potential sanction if the allegations are upheld. The hearing should also be held by someone else who has not been involved in the process already and is therefore impartial. At the disciplinary hearing, the concerns should be clearly explained to the employee, asking them to provide their version of events, to comment on the evidence, and to give them an opportunity to respond to any inconsistencies in their version of events. This will help the disciplinary officer reach a conclusion on the evidence as to whether the disciplinary allegations can be upheld, or whether no further action is to be taken, which they then should confirm in writing to the employee, explaining why they have reached the decision that they did. It is important that everything in the disciplinary process is documented. Invites to meetings, notes of meetings, the evidence that was gathered and considered, and decisions clearly explaining how those decisions were reached are set out in the outcome letter. The employer should also offer a right of appeal where the outcome involves a disciplinary sanction, and all of this will help ensure the overall process is considered fair and reasonable. In terms of common mistakes to avoid, as I mentioned at the start, one of the biggest risks I see when advising on disciplinary processes are managers acting too quickly and on their own instincts, rather than pausing and following a fair process as we have just discussed. Another common risk is skipping the investigative stage of a disciplinary process. When justifying a disciplinary sanction, the manager needs to demonstrate they held a reasonable belief in the employee's wrongdoing, but that belief must be based on evidence, and the evidence is largely gathered as part of an investigation, so it's important not to skip the investigative stage. Finally, managers should ensure cases which are similar are dealt with in a similar way, and in line with the company's disciplinary policy, unless of course there are genuine reasons why 2 cases can be treated differently. This may be based on the facts of those cases, or even based on mitigation offered by the employee as to why they acted the way that they did. If dismissal could be an outcome, or the issue feels serious or complex, pause and get HR or legal advice before proceeding. It would also be worthy of HR or legal advice if the sanctions are as a result of potentially an employee's disability. Thank you very much for watching. You can find more helpful resources to support disciplinary processes on the Breathe Growth Academy.